All right, man. Welcome back to the channel, to the Butterfly Monkey Effect. Hopefully you guys are caught up and all the proper videos have been watched and you guys have learned something, and hopefully you guys have questions. This is part 7 of this book. I know I'm making a lot of videos and I'm purposely not making them an hour and a half long. I figured maybe 5 more videos. I'm hoping, but I don't know. We'll see. We will see. But to continue, this is part B of this section, and it's another court case called Dayton versus Dulles. For the full opinion, including dissenting opinion, see the appendix. Okay, so it says, this case was also decided by a 5-4 majority with the same justices dissenting and for the same reason. So they're talking about the case of Kent versus Dulles, Briel versus Dulles. The court stated, petitioner, a native-born citizen, is a physicist who has been connected with various federal projects and who has been associated as a teacher with several of our universities. In March of '54, he applied for a passport to enable him to travel to India in order to accept a position as research physicist at the Tata Institute of Fundamental Research, affiliated with the University of Bombay. In April of '54, the director of the passport office advised him that his application was denied because the Department of State feels that it would be contrary to the best interest of the United States to provide you a passport facilities at this time. Petitioner conferred with an officer of the passport office, and as a result of that conversation, executed an affidavit which covered a wide range of matters inquired into and which stated in part, I am not now and I have never been a member of the Communist Party. So he's actually doing an affidavit where the other guys refused. I'm guessing that the whoever he spoke to at the passport office asked him for this. Well, it was the result of the conversation. With the possible exception of a casual and brief association with the work of the Joint Anti-Fascist Refugee Committee for a few months in 1941 and 42, all as related below. I am not now and never have been a member of any of the organizations designated on the Attorney General's list, which I have carefully examined. I am not now engaged, and I have never engaged in any activities which, so far as I know, or at any time knew, support or supported the communist movement. I wish to go abroad for the sole purpose of engaging in experimental research in physics at the Tata Institute of Fundamental Research in Bombay. I am not going abroad to engage in any activities which, so far as I know or can imagine, will in any way advance the communist movement. The director of the passport office wrote petitioner's lawyer in reply that the department had given careful consideration to the affidavit and added, in view of certain factors of Mr. Dayton's case, which I am not at liberty to discuss with him, the department must adhere to its previous decision that it would be contrary to the best interests of the United States to provide Mr. Dayton with a passport facilities at this time. You know, why do you think they keep repeating this right here? Passport facilities. Right, to provide Mr. Dayton with passport facilities. Why not just with a passport, since that's what he's specifically asking for, right? It's really what it offers. This is what that says. It's what the passport offers. I would have to guess that's like the context of it. Later, the director wrote again saying, in arriving at this decision to refuse passport facilities to Mr. Dayton, the department took into consideration his connection with the Science for Victory Committee and his association at the time with various communists. However, the determining factor in the case was Mr. Dayton's association with persons suspected of being part of the Rosenberg espionage ring and his alleged presence at an apartment in New York, which was allegedly used for microfilming material obtained for the use of a foreign government. Thereupon, petitioner, pursuant to passport regulations of the Secretary, as amended in 51.1, which now it's that those are just definitions now, filed a petition of appeal with the Board of Passport Appeals. He also requested, pursuant to the regulations, information from the Board of Particulars concerning 3 items. 1. Petitioner's alleged association with various communists. 2. His association with persons suspected of being part of the Rosenberg espionage rig. And 3. His alleged presence at an apartment in New York. So he's about to fight all 3. Which was allegedly used for microfilming material obtained for the use of foreign government. The board's reply contained some, but very little, of the information requested, and it stated, the file contains information indicating that the applicant was present at 65 Morning Street, New York City, in the summer of '49, July or August, and at apartment 61, 65 Morning Street, New York City, during the month of January 1950. The applicant's relationship, if any, past or present, with the following named persons is considered pertinent to the board's review and consideration of the case. Marcel Scherer, Rose Segur, Sandra Collins, Frank Collins, Bernard Peters, Kurt Fritz, Carl Sitt, Louis S. Weiss, Alfred Serrett, and William Pearl. A hearing was held at which witnesses for petitioner and for the State Department testified. Pursuant to the regulations, the board announced over petitioner's protest that it would consider a confidential file composed of investigative reports from government agencies. You know what's tripped out is, if you notice, some of the cases that we read, right, they are losing those cases. But the ones that they're winning are the ones where they're they're saying that they have confidential information. Report from government agencies which petitioner would not be allowed to examine. Later, petitioner was advised by the acting Secretary of State that the board had submitted its recommendation and that the Secretary, after a review of the entire record and on the basis of all the evidence, including that contained in confidential reports of investigation, had denied the application. The denial was based specifically upon 51.135 of the regulations. Oh, what I just lost my sound. Petitioner then brought suit in the district court for declaratory relief. The district court entered summary judgment for the Secretary. The Court of Appeals reversed, so he wins that, and remanded the case to the Secretary for reconsideration in the light of the earlier decision of Bowden Dulles, which rightly so. On remand, the Secretary, without further hearing, denied the application under 51.135C. So now they're being specific, right? Saying that the issuance of a passport would be contrary to the national interest. The Secretary at this time filed a document called Decision and Findings, which is reproduced as an appendix to this opinion. So it's down below still, I think. The district court again granted summary judgment for the Secretary, and the Court of Appeals affirmed by a divided vote, which is the 5-4. The case is here on a petition for a writ of certiorari. The question most discussed in the briefs and on oral argument is whether the hearing accorded petitioner satisfied the requirements of due process. A majority of the court thinks we need not reach that constitutional question, since on their face, these findings show only a denial of a passport for reasons which we have today held to be impermissible. Kent versus Dulles ante, which whether there are undisclosed grounds adequate to sustain the Secretary's action is not here for decision. So another loser. Well, it says reversed, but that's reversed back to the initial finding, so he lost. Worthy versus Herter, June 9th, 59, certiorari denied. So it didn't go to the Supreme Court. Our appellate, William Worthy Jr., was a newspaperman duly accredited by the Afro-American newspapers of New York Post and the Columbia Broadcasting System. In 1957, he applied for renewal of a passport originally issued to him in 1955. The passport contained a restriction stating that it was not valid for travel to 5 named areas under control of authorities with which the United States does not have a diplomatic relations, including the portions of China, Korea, and Vietnam under communist control, and also a restriction against travel in Hungary. After various proceedings, Worthy was asked whether he would make a commitment to abide to the restrictions. He was asked. He declined to do so, and the renewal was refused. The background for the refusal was that when the passport was originally issued, it contained the same restrictions, but Worthy nevertheless traveled extensively in both communist China and Hungary. The refusal of the passport rested in no part upon Worthy's personal beliefs, writings, or character. It was an application of the Secretary of State's general policy of refusing government sanction to travel to by United States citizens to in certain areas of the world presently under communist control, and deemed by him to be trouble spots. We note immediately that the point here presented in no wise resembles the matter decided by the Supreme Court, Kent versus Dulles. There, the court held that the secretary refused passports because of the beliefs and associations of the applicants, and that he had no statutory authority to refuse on such grounds. All right. Let's highlight that since it's specific. Oh, crap. In the case at bar, no beliefs, associations, or personal characteristics are involved, nor is this a case in which the secretary has proposed a restriction upon a passport for reasons of internal security, i.e. protection against internal subversion. The factors here are political and military conditions in certain areas of the earth. Worthy makes 4 points. 1. He says the right to travel is a constitutional right and may be abridged only when there are overriding considerations of the public safety. 2. The secretary lacks statutory authority to deny a passport to prevent travel in these countries. 3. Alternatively, to the extent the refusal rests upon executive power over foreign relations, it is still subject to applicable constitutional provisions, and the reasons given by the secretary do not warrant this abridgment. The refusal is an abridgment of the freedom of press. Worthy says correctly that the denial of the passport under the statutes of today, 1960, whatever that year was, 57, must be justified as a denial of a right to travel. And he says also correctly that the right to travel is protected by the Constitution, being a part of the right of liberty, which is great right here. Let me highlight this stuff right here. The right to travel is part of the right to liberty, and a newspaper's right to travel is a part of the freedom of the press. But these valid generalizations do not support unrestrained conclusions. For the maintenance and preservation of liberty, individual rights must be restricted for various reasons from time to time. In case of a clear and present danger of the national security, even so generally unrestrictable, a right as speech can be restricted. Liberty itself is inherently a restricted thing. Liberty is a product of order. There is no liberty in anarchy or in chaos. Liberty is achieved by rules which correlate every man's actions to every other man's rights, and thus, by mutual restrictions, one upon another, achieve a result of relative freedom. That's pretty good right there. Even in the neighborhood community, every man's right to roam is drastically restricted. A man who asserts his own uninhibited freedom to go where he pleases is a menace and is quickly put in his place. He may not park where he pleases, or drink where he pleases, or spit where he pleases. In the community, the police take care of those matters, and in so doing, the officers act as servants of the rest of the community. They are the government. Freedom of press bears restrictions. It does not include the right to publish what another has registered with the Copyright Office. Merely because a newsman has the right to travel does not mean he can go anywhere he wishes. He cannot attend conferences of the Supreme Court, or meetings of the President's Cabinet, or executive sessions of committees of the Congress. So we conclude on the point, all those points that he fucking made are like off point. You guys caught that? Almost all of these are like off point. He's taking it like to some extent to where, like, you know, a government meeting and stuff, like, oh, well, okay, well, I can't attend, or what? All right. But that's not this case. It's another location in the world. So we conclude on the point that the right to travel, like every other form of liberty, is, in our concept of an ordered society, subject to restrictions under some circumstances and for some reasons. The next questions are what restrictions are here sought to be imposed by the Secretary and why he seeks to impose them. Worthy seeks an unrestricted passport so that he may travel anywhere in the world. He wishes especially to enter certain countries now under communist control, which, like most others, require him to possess a valid United States passport. He advised the Board of Passport Appeals he had written Premier Chou En-lai that he sought full information about any and all news stories, especially stories that involve the risk of war, as is the case with current Chinese-American issues over Taiwan. Quemoy and Matsu. So there's three places: Taiwan, Quemoy, and Matsu. I wonder what happened to them, right? You know, Taiwan is still, you know, half independent or whatever. But they're to this day they're surrounded right now. But these, I didn't even heard of these. The Secretary will not issue him a passport unless Worthy says he will not enter these designated countries. Thus, Worthy is now free to travel in public places in the United States, Canada, and Mexico. And if he agrees to the restrictions, he will be free to travel in places open to foreigners in all countries, which will grant him visas except those named by the Secretary. The quantum by which Worthy's freedom has been reduced in this area of places open to foreigners in those of the 6 named countries which might grant him visas. No restrictions are proposed upon Worthy's thinking or writing. The restrictions proposed are on his physical presence in specified zones in foreign countries. They are restrictions upon acts, i.e. travel. The Secretary has given 2 separate but related reasons for this reduction of Worthy's freedom. 1. The areas named are potential and actual trouble spots, where the presence of American citizens may place them in danger and further irritate our relations with the named countries and our allies. That's a bullshit reason. To say trouble spots and the presence of Americans might be in danger, that's a given anywhere in the world. Trouble spots, that could be something specific, right? Specific hostilities with the government, right? That's different, right? But you could be hurt anywhere in the world. 2, The presence of American citizens in these areas and the official approval of their presence there will impede the execution of American foreign policy in relation both to these countries and to other countries. The fact which caused the Secretary to designate these places and to refuse official sanction to travel therein are shown us by the Secretary. Indeed, too far. Indeed, they are established by many current events. They appear almost daily upon the front pages of the newspapers. They have been declared repeatedly by the President, his predecessors, and the Congress. We need not catalog them. The Korean difficulty with Communist China is still in the armistice stage, not finally settled. Still not settled. All trade with that part of China is prohibited. The situation in respect to Formosa and the small offshore islands where we have a treaty of mutual defense fluctuates in intensity. We oppose Communist China's membership in the United Nations, which they are now, right? What is it? I forgot the year, but it's recent. You're talking about like in under 20 years, I think, that they finally participated or are in the United Nations. American citizens are held in hostage in that country. The reasons underlying the restriction on travel in Hungary are less numerous, but apply sufficient. Unless almost the whole of our foreign policy and the titanic domestic burdens being presently borne by our people are devoid of factual foundation, there is presently in the world of deadlock of antagonistic forces, susceptible of erupting into a fatal cataclysm. The capacity of incidents arising from the conduct of individuals to ignite that conflagration is well proven. Conflagration is like the spread of the fire or something like that, to make it worse. At least that's how I take it. Worthy says the reasons averred by a variable or available to the Secretary are insufficient to support the restriction of his passport. We hold that they are ample. Designations of restricted areas are made from time to time by the Secretary and thereafter are frequently withdrawn by him. Such has been a customary practice. For example, travel to Hungary was restricted on December 21st, 1949, and the restriction was lifted upon the release of Robert Volger. The same thing happened in Czechoslovakia in 1951 in connection with the Otis incident. We think the designation of certain areas of the world as forbidden to American travelers fall within the power to conduct foreign affairs. The bare determination that certain areas outside this hemisphere are trouble spots or danger zones is a phase of foreign affairs, and I agree with that. There's plenty of court cases that I read that has shown that. Let's highlight this though, because even though it's not specific to like what I want, but it's still. The assistance the Congress requires the President to afford an American citizen in trouble abroad is a phase of foreign affairs. The instrumentalities he must use to fulfill the congressional mandate are diplomatic. For Foreign Service Counselor or Foreign Service Counselor, a decision on the part of the President to prevent, if possible, the necessity for calling into play his diplomatic instrumentalities and the use of his powers, persuasive or compulsory, upon a foreign nation is a phase of foreign affairs. The selection by him of the means to be used in a given such case rests in large part upon policy, obviously foreign policy. If then the designation of a foreign area as a political trouble spot is a foreign affair, and the extradition of a citizen from trouble in a foreign country is a foreign affair, is the refusal of the executive to accord government approval for a citizen to travel in such a designated area also a foreign affair? We think it is. The essence of the conduct of foreign affairs is the maintenance of peace and prevention of war. The Constitution places that task of prevention in the hands of the executive. The two correlative powers to conduct war and to prevent war are executive functions under our Constitution. That's a hell of a way to put it, though, because it's all these are implied powers. So he gives two power, the power to conduct war and the one to prevent war, and then all the implied wars that come with it, for you could execute the primary power. We think that if the executive foresees that the presence of American citizens in a designated foreign area may, by reason of military or political conditions there, sorry about that. Oh, lost my spot. We think that if the executive foresees that the presence of American citizens in a designated area, foreign area may, by reason of military or political conditions, there evolve into or be the occasion of a clash, diplomatic or military, with a foreign government, his power in respect to foreign affairs includes power to refuse to sanction the travel of American citizens in that area. To hold the contrary would be to hold that the protection of the peace against American caused incidents in foreign countries is outside the realm of foreign affairs. They're saying to hold the contrary would be to hold that the protection of the peace against American-caused incidents in foreign countries is outside the realm of foreign affairs. Such latter holding would be both illogical and unrealistic. In foreign affairs, especially in the intimate posture of today's world of jets, radio, and atomic power, and individuals' uninhibited they say yen, to go and to inquire may be circumscribed. I don't know what yen would mean here, outside the obvious. Maybe it's a misprint. I know if I search it, it's going to give me the currency, and I'm never going to find out what it means. A blustering inquisitor avowing his own freedom to go and do as he pleases can throw the whole international neighborhood into turmoil. Worthy's avowed intent is to seek especially stories that involve the risk of war. Worthy argues that the Secretary does not have statutory power to designate restricted geographical areas. We think, as we have indicated, that the President has ample power under the Constitution itself. His delegation to the Secretary is complete, but if the power to act rests upon statutes, we think the existing ones are clearly sufficient. Section 1185B of Title 8 provides that while a proclamation of national emergency is in force, it shall, except as otherwise provided by the President, and subject to such limitations and exceptions as the President may authorize and prescribe, be unlawful for any citizen of the United States to depart from or enter or attempt to depart from or enter the United States unless he bears a valid passport. The President delegated this authority to the Secretary by Proclamation number 3004. On this point, we appeared in Brill versus Dulles, Supra, to be in agreement. In his dissenting opinion, Judge Bazelon said, referring to Proclamation 3004, thus read, it grants the Secretary discretion of the type already exercised in his existing travel control regulations, namely to determine which parts of the world can be visited by Americans, only if they have passports, but not to determine which Americans are to receive passports. The 1926 Act contained an unequivocal provision. The Secretary of State may grant and issue passports. The Supreme Court said in Kent versus Dulles, under the 1926 Act and its predecessors, a large body of precedents grew up which repeat over and again that the issuance of passports is a discretionary act on the part of the Secretary of State, Scholars, the courts, the chief executive, and attorneys generals all said so. If the secretary has any discretion, and it seems to us it must include a discretion to prevent trouble when he reasonably foresees trouble. Without a preventive discretion, he has no discretion of any realistic content. Reasonable basis for the Secretary's anticipation of possible involvement appears in ample measure in this case. So we think the statutes, if they have any meaning at all, include the power to do what the Secretary did in the case before us. It is said that many of the incidents involved in the reported court case dealing with foreign affairs were in time of war. But foreign affairs involve more than wars, and the president's powers over foreign affairs are not only war powers. As a matter of fact, these are two separate powers in the Constitution. And as a further matter of fact, governments have many more dealings with each other and problems concerning each other in peacetime than they do in wartime. Not only so, but as we have already emphasized, the duty of the president to prevent war is as important as his power to conduct one. Were the errors when he assumes that the secretary is forbidding him to travel at all, or that the action is a tantamount or imprisoning him. Right? He assumes that the secretary has forbidden him to travel at all, or that the action is tantamount to imprisoning him. Worthy, so far as this record shows, can have a passport to travel all over the world, except in certain designated areas. He is in no sense imprisoned, except in the same rhetorical sense, although in less degree. That man is imprisoned because he is earthbound. Worthy says situations which demand curtailment of constitutional rights must be of an exceptional and severe emergency nature, clear and present danger, gravest imminent danger, etc. Several comments may be made. In the first place, the nature of the rights and the nature of the restrictions are important. As we have already pointed out, the right here involved is not a right to think or speak. It is a right to be physically present in a certain place. The basis of the restriction is not personal, but is the military and political situation in the designated areas. In the second place, there is a grave, clear, and present danger, as we have indicated. When a gunman points a loaded gun, one need not await the report from a shot to know that danger is clear and present. The contention that there is no grave danger involved in the wanderings of uninhibited American newsmen in China or in Hungary today reflects an unawareness of realities. In the third place, the Constitution puts in the president the authority to evaluate the military and political exigencies. I can't pronounce a lot of these words no more. Ever since I had that, what was that, cerebral palsy or whatever, that thing where you get a microclot and it paralyzes part of your face and shit. That's happened to me almost 2 years ago now, and I haven't been able to say some words no more. Exigencies in foreign countries. The courts are the least able of all organs of government to make such evaluations, and they are wholly without authority to make them. To order the Secretary of State to do something because we believe it would be better for our foreign relations than his plan would be a gross usurpation of executive powers. Judgment on what course of action will best promote our foreign relations has been entrusted to the president, not to the courts, journalists, scholars, or even public opinion. He makes his decision with the aid of the Department of State, a large organization with stations throughout the world, as well on the basis of information received from all parts of the world as well all parts of the executive branch. All parts of the executive branch. We, if we had all this information, might reach a different decision, but the Constitution was wisely placed that burden in the hands of one who must justify his decisions before the electorate. The judgment of the district court is affirmed. So another loser. Frank V. Herter in 1959, certiorari denied. The plaintiff was a writer, teacher, and lecturer who had an invitation to lecture at the capital of Communist China. He sought unsuccessfully in the court below removal of a travel restraint clause respecting communist countries in his passport, and to enjoin enforcement of sanctions against him when the Secretary of State granted travel rights to 25 or 30 representatives of various news services on an experimental and temporary basis, while denying the same rights to him. The Court of Appeals, in the brief, one paragraph per curiam, decision upheld the court below on the basis of the decision in Worthy, the one we just read. One judge, in a concurring opinion, considered the question of discrimination and concluded that the Secretary's action was not discriminatory. New York versus O'Neill, 1959. This case, although it does not involve a passport question, is included here to show that the right of travel, even within the United States, is not an absolute one. Only that part of the majority and dissenting opinions are given where the right to travel was discussed. Let's highlight that real quick. This case is before us to determine the constitutionality of a Florida statute entitled Uniform Law to secure the attendance of witnesses from within or without a state in criminal proceedings. Respondent, a citizen of Illinois, had traveled to Florida to attend a convention. In accordance with the Florida statute, the Circuit Court of Dade County, Florida, responded to a certificate executed by the judge of the Court of General Sessions, New York County. In accordance with the Florida statute, the Circuit Court of Dade County, Florida, responded to a certificate executed by a judge of the Court of General Sessions, New York County, under New York Code, Criminal Code, by summoning respondent before it to determine whether he was to be given into the custody of New York authorities to be transported to New York to testify in a grand jury proceeding in that state. The Circuit Court, ruling that Florida statute violated the Florida and the United States Constitution, refused to grant New York's request. The Supreme Court of Florida affirmed this decision on the ground that the statute violated the United States Constitution. We granted certiorari in as much as this holding brings into question the constitutionality of a statute now in force in 42 states and the Commonwealth of Puerto Rico. More fundamentally, this case does not involve freedom of travel in its essential sense. At most, it represents a temporary interference with voluntary travel. Particularly, this is so in an area of jet transportation when vast distances can be traversed in a matter of hours. Respondent was perfectly free to return to Florida after testifying in New York. Indeed, New York was obligated to pay his way back to Florida. Or after testifying, he could return to Illinois or remain in New York. The privilege of ingress and egress among the states, which has been urged in the opinions, is of hardier stuff. The privilege was to prevent the walling off of states, what has been called the balkanization of the nation. The requirement which respondent resist conduces, it merits repetition, toward a free-willed collaboration of independent states. The United States Supreme Court reversed the Florida Supreme Court. The dissenting opinion said with respect to the right to travel, the right to free ingress and egress within the country and even beyond the borders is a basic constitutional right, though it is not contained in hoc verba. Let's look up what that is. What just happened? Did I not copy this? Okay. Learn the meaning and usage of the Latin phrase, which means in these words, and is used to quote an agreement verbatim. Like, I agree with everything you're saying, right? The right to free ingress and egress within the country and even beyond the borders is a basic constitutional right, though it is not contained in hac verba in the Constitution. It had been included in the Articles of Confederation, Article 4, of which provided in part, better to secure and perpetuate mutual friendship and intercourse among the people of different states in this union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted. So here's the acceptance, right? They restrict your certain fundamental rights or privileges and immunities, right? Under Article 4. If you're a pauper, a vagabond, or a fugitive. And now you know why you get treated the way you do if you are a pauper. Fugitives from justice excepted shall be entitled to all the privileges and immunities of free citizens in the several states. And the people of each state shall have free ingress and regress to and from any other state. And this is the key thing, man. Like, people don't seem to understand. Like, this concept right here, where they're telling you you get all the privileges and immunities of a free citizen, except if you're a vagabond, a pauper, or a fugitive. Fugitive is obvious, right? A vagabond, just a bum. And a pauper, he is in desperate need of help from the government. As Chaffee, Three Human Rights in the Constitution, 1956, states, the failure to make specific provision for this right in the Constitution must have been on the assumption that it was already included. For it is impossible to think that a right so deeply cherished in the colonies was rejected outright. The convention carefully prevented states from passing tariff laws. Surely it did not want state immigration laws. The Constitution was designed to secure the freest intercourse between the citizens of the different states. And Chief Justice Taney, in the passenger cases, said Chief Justice Taney so this right here. The Constitution was designed to secure the freest intercourse between the citizens of the different states, said Chief Justice Taney in the passenger cases. And he added, for all the great purposes for which the federal government was formed, we are one people with one common country. We are all citizens of the United States, and as members of the same community, must have the right to pass and repass through every part of it without interruption, as freely as in our own states. This right of free ingress and egress is one arising out of the nature and essential character of the federal government. They give you another court case, Duncan versus Missouri, twinning, fears. They said these already. But let's highlight this right here. Undoubtedly, the right of locomotion, the right to remove from one place to another according to inclination, is an attribute of personal liberty, and the right ordinarily of free transit from and through the territory of any state is a right secured by the 14th Amendment and by other provisions of the Constitution. It has often been called a right or privilege of national citizenship, and that's Crandall, with 5 others. Slaughterhouse cases, look at Slaughterhouse cases, Twining, Edwards. As such, it is protected against state action by the Privileges and Immunities Clause of the 14th Amendment. Well, protected against state action, right? But you would use what? The Bill of Rights, literally the Fifth Amendment, to fight against federal action. Where did I leave off? It has at times been considered under the protective care of the Commerce Clause, subject to control by Congress, but free from stoppage or impairment by the states. In Kent versus Dulles, we held that this right to travel was a part of the citizen's liberty within the meaning of the Due Process Clause of the Fifth Amendment. I know I'm highlighting things that seem to be a repetition, so it is, fuck it. I don't want to miss it. You know what I'm saying? I'd rather read it twice than skip over it and not read it again ever again. Freedom of movement across frontiers in both directions and inside frontiers as well was part of our heritage. Travel abroad, like travel within the country, may be necessary for a livelihood. It may be as close as to the heart as the individual as the choice of what he eats or wears or reads. Freedom of movement freedom of movement is basic in our scheme of values. Whatever may be the sources of this right of free movement, the right to go to any state or stay home as one chooses, it is an incident of national citizenship and occupies a high place in our constitutional values. Let's do all this. I'm pretty sure this is Kent Dulles, though. This right is of national citizenship and has been qualified. One qualification was made by the extradition clause of Article 4, Section 2 of the Constitution. A person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. But that limitation on the right of free movement applies only when the citizen is a fugitive of the law. Right? Those things don't apply to him no more. That's the whole thing, man. Okay, I think I'm going to end with this one right here. Let me see where we at right here. 48 minutes. Pretty good, pretty good. Remember to start reading this at 1.5. I should have probably said this in the beginning of the videos. Listen to these videos at 1.5 and you'll blow past these. And if you get good at it, you'll hit 2.0 like I do. All right? So thank you for watching. Hope you guys enjoyed it. Have some questions. Find me on Telegram. Find me on TikTok. And, of course, you can find me, always message me here on YouTube, and I'll try to reply. I have my Telegram information somewhere on here. So you guys can always find me. But for now, until next time, thank you for watching, guys. Take care.